Well, good afternoon, everyone. My name is Eileen Harris. I'm the Executive Director for the Alabama Center for Dispute Resolution. And on behalf of our sponsors, the Dispute Resolution Section of the Alabama State Bar and the Center, we are grateful that you're joining us today to learn about best practices in arbitration. We've got a great lineup for you today, and welcome to our webinar on best practices in arbitration. And at this point, I'd like to hand it off to our presenters.
Thank you, Eileen. We appreciate it. Welcome, everyone. I'm Jon Lewis. I'm a practicing attorney in Birmingham, Alabama. I've been practicing for about 30 years, mostly in the plaintiff's personal injury realm, but I was registered as a mediator in 2017 and in 2020 as an arbitrator. I'm a registered arbitrator with FINRA. Most of my practice in arbitration has been as an advocate, but I've also been on several panels with FINRA, which is the Financial Regulatory Agency. And I practice with Lewis and Feldman. My partner is Danny Feldman here in Birmingham. We also have here Cooper Shattuck, the Sultan of the bow tie. Cooper is well renowned. He was general counsel for the University of Alabama system. He's been a chief legal advisor for the governor. He's taught numerous courses at the Alabama School of Law on alternative dispute resolution as well. He gives many CLEs. We're very honored to have you here. He has his own practice, Cooper Shattuck LLC, and I think cartography is another business that Cooper consults on marketing and other legal services. And then we have Brooke here today, and we're very fortunate to have Brooke, who's an attorney at Capella and Howard. Brooke has been practicing in the construction industry mostly, but he's also had experience in employment law. And Brooke is also a registered mediator. Both Brooke and Cooper are on the panel for the American Arbitration Association as arbitrators and mediators. And we're glad to have you here as well, Brooke. We have a lot of information to go over if you've looked at the outline. I think a lot of our focus will be on section 4, but we want to get started with what to consider when you agree to arbitrate. You either have to, before you arbitrate, you have to have either an agreement among all the parties, or you have to have a contract that everybody signed. And so I'll throw it to you, Brooke and Cooper. What are some of the considerations we need to look at when considering arbitration? Start with you, Brooke.
Well, obviously, the first thing to consider is whether or not you do, in fact, have an arbitration clause in your contract, assuming that you do have a contract. And it's important to, if you do have such a clause, it should go without saying, but you need to read, it may dictate the type of arbitration that you've agreed to, the applicable rules. It could be a consumer arbitration, it could be a commercial arbitration, it could be a construction arbitration. And with those different rules come different fees, for example, different discovery procedures, the costs can be significantly different between a consumer and a commercial. It may dictate that you have a fast track arbitration versus just a standard arbitration. It may dictate the locale. So I always encourage everyone to start off by reading it. Don't just assume that, oh, it's an arbitration clause and that's all it says, because very often they'll provide a lot more detail than that.
Yeah, I think too, the thing that people often forget is it is an arbitration agreement. It may have looked like a contract of adhesion, but it's an agreement, and that's the way we treat it, which means it can be modified by agreement. So if the agreement calls for arbitration under the commercial rules and the parties decide that there's some other rules more applicable, they can agree to that, or they can modify the rules. And I think as arbitrators, we're governed by the agreement, whatever it is, and it can change. And I think the parties need to remember that so that they make sure whatever it is they agree to really fits their needs.
And I would agree. And you also have to look at the different organizations governing the contract. You know, and with what you said, Cooper, a lot of times you don't have to go with the organization. You don't have to go by AAA or FINRA. the parties can go off script and choose their own arbitrator and decide to apply different rules if they want to. So I think that's a great point.
Yeah.
Yeah, and to that point, since John mentions that you can go off script, if you have an arbitration agreement that, for example, provides for JAMS or AAA or FINRA to administer the arbitration, the parties can agree to waive that requirement and proceed with private arbitration. If they do that, I would, and I always do, encourage the parties, if they want to retain us for private arbitrations, that they do at least agree to apply the rules, the procedural rules of one of these organizations to the dispute. It does, I think, help even if you're not going to use the AAA's administrative services, to at least apply the AAA rules to your arbitration.
And I would offer one other thing, if I might. I think one thing that a lot of people, at least several years ago, the knee-jerk reaction was, if there's an arbitration agreement, let's arbitrate. But that doesn't necessarily have to be the case. When we say go off script, it might be better to litigate, especially if you can have a judge and not pay all the costs. What are y'all's thoughts on that?
Yeah.
Yeah. Go ahead, Brooke.
Well, certainly the parties can agree that they want to proceed. And let's use the example of a relatively small case, dollar-wise. It may be beneficial to them to proceed in small claims court as opposed to arbitration. And they can certainly agree to do that. And it's incumbent upon lawyers to evaluate their clients' cases and weigh the pros and cons of going to court versus going through arbitration. But they can certainly agree to waive that requirement.
Yeah, especially if the agreement mandates a 3-panel arbitration and the case is not worth a 3-panel arbitration.
Right.
Yeah, I had a judge one time tell me, why do y'all want to go to arbitration when you got a free arbitrator right here? And I was in total agreement in that case.
Yeah. Yeah, I think I should have said this at the beginning, and I'm not speaking for Brooke, but he can agree or disagree. I want to make clear that all the opinions that I'm giving today are mine, not AAA's. I'm on the AAA panel, but these are my opinions, not theirs. So, I will say this about third-party administration versus private. The knee-jerk reaction also seems to be, gosh, we don't want to use fill in the blank, AAA, whomever, because it's so expensive. But the administrative services they provide are really fairly inexpensive when you start figuring what you're going to pay somebody else to do all those things. So I'd say check it out. They've modified their fees in the last few years. And so what used to be an expensive commercial process, the consumer rules are pretty broad and apply to bigger disputes than you would think. And they're much less expensive than they used to be.
Yeah, that's a good point, because oftentimes we do hear complaints about the administrative fees, but you need to keep in mind that if you elect to not go with JAMS or AAA to administer the case, then you're asking the arbitrators or arbitrator singular to administer the case. And that's going to be an additional expense for the arbitrator to have to do that. So that is an important consideration.
Absolutely. And you have to consider that the purpose of arbitration is to make the system, the process more efficient and streamlined, which is another consideration, I think, before you look at whether you arbitrate versus litigate, is who is that person who's going to be handling the efficiency of the process. Any thoughts on that?
I can speak for AAA. They very much encourage their arbitrators to remember why the parties chose arbitration, and that is a streamlined, efficient process. So we are encouraged by AAA, and I don't think they're wrong to say this, to not let the arbitration become something it wasn't intended to be, which is an expensive, drawn out process. So at every step along the way, I try to, and I'm sure Brooke does too, and you too, John, even outside of AAA, try to make sure that we do streamline the process, that we're not delaying it or allowing any one party to delay or prolong it.
And one other point I'll make in this topic, and I think Cooper, you've raised this before when we've been together, and that is, before you agree to mediate or litigate, get together with the other parties, talk to each other. I think in this day and age, a lot of us don't pick up the phone sometimes.
Right. Haul off and file an arbitration demand, and it could have been worked out.
Right. So should we look to what are we looking for in an arbitrator? Brooke, you want to take that one?
I do. And John, before we move on, if I might, you did touch on it, the one arbitrator versus a panel of three. And,
Right.
Under the AAA rules, depending upon the size of your case, if the dollar amount meets a certain threshold, then it automatically will trigger the appointment of a panel of three arbitrators rather than just one. But the parties, again, because this is party driven, the parties can agree, even though the rules provide for a panel of three. If the parties agree, they can select just a single arbitrator and thereby reduce their costs. So just because the rules say three doesn't mean that that's what you have to go with. And the flip side's true. Your claim may not meet that threshold, but you may want a panel of three, and you can request that. That's certainly well within rules of the AAA.
It's a great point.
Okay, yeah. So moving on to the next section is what to look for in an arbitrator. I'm sure the three of us hope that what you're looking for, we fit that need. But John, tell us why neutrality and impartiality are so important when you're looking for an arbitrator.
Well, clearly you want somebody who's fair and can rule according to the balls and strikes and not one side or the other. We want, just as you want a judge who's fair and going to rule according to the law and to the rules, you want an arbitrator to be the same. And I think, your reputation precedes you and whether you're that person. So you don't want either side to feel like they're being favored one way or the other, because that's what you're a neutral. And, if you're going to be a neutral, you got to act as a neutral. So I think, clearly you want the parties and the attorneys to feel like they're getting a fair consideration by that ultimate decider. The arbitrator's deciding the case. It's not mediation. So you need, not that you don't want a mediator that's neutral, that's not neutral, but you need that arbitrator that you feel confident in is going to rule according to the law and to the rules.
Yeah, I think one of the measures too, and this has gotten a lot of attention by the AAA in particular. The disclosures that we have to fill out in every case as a AAA arbitrator, and John, you can speak to your experiences too, but I mean, it is a lengthy disclosure in every case. Any of the parties, ever done work with any of the lawyers, but it's a lot more than that. There's probably 30 questions or more. And in some cases, I have to fill out the California required disclosures, which is statutory for arbitration, which are even longer. So my word of caution on neutrality and impartiality is if you agree to private arbitration where you don't have mandatory disclosures, you ought to be asking for those disclosures from your arbitrator, because otherwise they don't have any duty to tell you that, oh, I've got a case with this person, or I used to, represent that person, or I know this witness, or whatever the case may be. John, does your group?
FINRA is extensive. I mean, you have to give them every brokerage account you have, every bank account that you have, any tax issues you've had. I mean, it goes, and every time you get a case, you have to go through it and file that oath. And if you ever have a change, you're supposed to update your oath as an arbitrator. So I agree with you. That's a great point about the private arbitrator. If you don't have one of these organizations, you need to ask for that information.
Absolutely. And for those in the audience who are not advocates, but arbitrators, if you're in a private
I have
arbitration.
lost my sound, John. Oh,
Can you hear us, Cooper?
I can, sorry.
Okay.
I was just going to say for those in the audience who are arbitrators, if you're in a private arbitration and the parties don't request disclosures of the sort that the AAA requires of us, I think it's incumbent upon the arbitrator to provide that. You don't want a question to come up midway through the arbitration about your impartiality or your neutrality. So if they don't ask for it, you need to provide it. That is the best practice, and one that I always use in a private arbitration myself. So experience, Cooper, what sort of experience do you look for? Are you looking for somebody who has lots of experience as an arbitrator, or are you looking for somebody who has lots of experience as a lawyer in the particular area of law that it's going to be litigated?
You know, I think this is a tricky topic that, you know, again, a knee-jerk reaction might lead you astray. If you get someone too knowledgeable about the subject matter, you know, they've had a case just like that or arbitrated 15 cases just like that, then you're battling a lot of information that you don't know of what their experience was. And they're going to try to be fair and neutral and impartial and all that sort of thing. But you're going to be battling, and they're going to be battling subconsciously or consciously that experience that they had in those other cases. So if technical knowledge is important, great. But if it's really not, a little knowledge is probably better than a lot of knowledge. And I would just say that's probably contrary to what our knee-jerk reaction would be, but it's something that should be considered.
I think you also want somebody who has experience to some degree in arbitration, and you want somebody who's not going to waffle back and forth, who's going to be able to make a decision. And I agree with what Cooper's saying about the subject matter, unless it's an overly complicated, extensive case. I think sometimes, you know, say patent law or something of that nature, construction, maybe you could speak to that, Brooke. You might need somebody who has a little more knowledge of the subject matter than, you know, somebody who has none. But, you know, from my perspective, when I've arbitrated as an advocate, as well as, you know, on some of my panels, I just think it's important that you have an arbitrator who can make rulings on, and we'll get to this later, on discovery and other issues, and not go back and forth and kind of waffle.
Yeah, depending upon the complexity of the case, and I practiced construction law most of my career, but depending on the complexity of the case, a party can request from the AAA that when they get a list of possible arbitrators to vet, that engineers, for example, be included on that. There are a number of AAA approved arbitrators who are not lawyers, but they're engineers or general contractors or architects. So if you believe that your case lends itself to needing that type of expertise, you can certainly request that the AAA include some of those, you know, an engineer or two on the list of prospective arbitrators.
Sometimes, and what we haven't addressed is sometimes the agreement itself specifies the qualifications for the arbitrator. So you need to look at the agreement before you make that decision too.
Yeah, I think you raised a good point, John. You know, somebody that's familiar, at least familiar substantively with the subject matter, can really expedite things. So there's a balance there, you know, because if you're having to explain terms of art to somebody who knows nothing about, you know, curtain walls or whatever, it's going to waste a lot of time. And it's going to also affect your client's confidence in the process. You know, it's like, hey, that guy doesn't even know what a, you know, ASM, whatever it is. And that's going to reflect in the whole tribunal and the impact that it's going to have on future arbitrations for that individual who has a bad experience.
Right.
Yeah, and for those of you who may not have arbitrated with the AAA before, and I'm sure JAMS does this, and FINRA probably does it as well, they'll provide you with an initial list of usually 10 prospective arbitrators and they provide their resumes. And it's important to review those resumes in detail. You know, what has been their experience as practicing attorneys? What has been their experience as an arbitrator? That can give you clues as to the type of arbitrator you think you might need, or an arbitrator that you think might not be as favorable to your client or your client's position. So do pay particular attention to those resumes as you're vetting arbitrators.
And reach out to other attorneys who've had experience. Do your due diligence.
Mhm.
So demeanor, that sort of falls within experience, but what do you look for in demeanor? And John, you kind of touched on it, and I think this does go to demeanor somewhat, is that you have an arbitrator who is willing to make the hard decisions. That's important. Not split the baby on every issue.
Well, I always go back to my practice and various judges, and we all have had those judges that we appreciate, have been respectful and been patient, versus those judges who've been somewhat disrespectful or not acted judicially. So I think you want an arbitrator who can make decisions, but who is also flexible and patient with respect to the advocacy. So I think you need flexibility, but you need somebody who is calm, doesn't get aggravated, and can be respectful to the parties while also moving the ball forward and keeping that efficiency so that the process serves the purpose.
Yeah. And John, again, you made a great point that just the fact that they can make a decision. I think about in my career, judges who were great people, but were terrible decision makers. I mean, just couldn't make a decision, and they were very pleasant, but that's not what we needed, you know? So, and you can't assume based on your experience with a mediator, for example, that, well, you know, they were so agreeable or so easy to work with, they wouldn't be a good arbitrator. And you can't assume that because somebody, you know, you just don't know how they're going to perform as an arbitrator unless you ask around and get some feel for their experience. You can't
And you can make a decision without being, you know, obnoxious about it.
Absolutely.
So,
Because nobody wants a bad experience.
Yeah.
You know, there's plenty of those to go around. We don't need any more of them.
All right, well, Cooper, you want to move on?
Yeah, let's talk about preparing our clients for arbitration. Obviously, preparation is important for everything we do. But Brooke, how do you approach, or how do you think it best to approach a client, whether it's a consumer or a corporation, for preparing them for the actual arbitration hearing or the process?
Well, most people are not as familiar with arbitration as they are with trial. They don't fully understand. Oftentimes, they don't fully understand the process, and so I always, if I know if my client has never arbitrated before, I always start off telling them that it is not trial. There's not going to be a jury. There's not going to be a judge in a robe. It's not going to be that formal, which is, to me, one of the great advantages of arbitration. I explained to them that while it is not as formal and it's not a judge, nevertheless, it is still a procedure where we need to show respect to the other parties and respect to the arbitrator as if he or she is a judge. I explained to them what the AAA rules are that apply to their case, what sort of expenses they can expect, what sort of time frame can they hope to get their case resolved in. Because, you know, too many people watch television shows or movies and think that it's going to be just like being in a courtroom, and it's just not that way at all. And they're surprised to learn that it is a lot less formal, and which, as I said, I think that is one of the great advantages of arbitration.
Yeah. John, do you think, do you see many people coming to you in arbitration who you get a sense that they are surprised or they weren't aware of what to expect?
yeah, I think that goes for some attorneys too. I think sometimes attorneys get there and they think oh, I'm going to send out all these subpoenas, I'm going to do all this discovery. And then they realize, well, that's not really the purpose of arbitration. It's to get this thing done. And as far as scheduling, and I know we'll get to that later, but I think a lot of attorneys don't understand, and that's why we talked about as far as litigation versus arbitration. You really need to think about that issue if you're not that familiar with arbitration and you have the choice to go to litigation. But you know, from a consumer perspective, because I've represented mostly consumers, when I've gone to arbitration, they totally don't understand what it is. And so you have to tell them, we're going to be in a conference room, we're not going to be in a courtroom, we're not going to get to do all this discovery. So there's definitely a lack of knowledge, I think, on a lot. I mean, obviously through the years it's grown, but I still think there's a lack of knowledge about the process.
Yeah. So what do you think is a key thing an arbitrator could do to try to help ensure that the parties are prepared before the hearing?
Well, I think a good idea might be to have a preliminary hearing with the parties there. But, you know, of course, you've got to get the other sides to agree, but I don't think that would be a problem at all. I mean, we are talking about alternative dispute resolution, even with arbitration. So the arbitrator can set those boundaries. So I think it'd be a good idea to get everybody in the room and talk about the process and how it's going to go.
Yeah. Brooke, do you do a sort of an introduction explanation at the beginning of a hearing to cover that with the parties and the counsel?
I do. I don't just assume that the lawyers have done that for their clients. That more often than not, they probably do. But I do give a brief introduction, not only of myself to the parties, but I explain the process to them to try to make them feel at ease with it. You don't want them in there in coming into the arbitration nervous, for example, that this is going to be it's stressful enough to be a participant. So I try to alleviate that stress somewhat by explaining the process and how it works, and reminding them that the whole process is driven by the parties themselves, and try to put them at ease on day one.
You know, it's interesting with FINRA, we go through that whole process with the attorneys, but the parties are never there. And they really don't get there until we have the hearing, maybe a year later. They don't know what's going on. So
that's the way it is with AAA too.
Yeah. It's rare that I ever hear from a party until the final hearing. And so that's why I do take 5 minutes just to kind of explain the process as I see it, and ask them if they have any questions before we get started.
Yeah, in my introduction, I try to remember to say, you know, we're here because this is how you all agreed that you wanted your dispute resolved. And every time I say that, at least one person in the room goes, you know, did we agreed to this? I thought we were forced to do this, you know. But it's important, I think, and we talked about this from the very beginning, to appreciate the context. Whether you actually read the contract you signed or not, the law presumes you did. And so we have to assume you did, or presume you did, and treat it that way. And so this is a process that you chose, you all chose, and we're carrying out your agreement. But yeah, I think that's an interesting idea, though, of getting the parties involved at the preliminary stage, just to make sure everybody's on the same page.
And I will say it would be good if attorneys, especially in a consumer case, explain that to their client, because I think you would get the deer in the headlights when you said that, you know, say it's a credit card dispute or a mortgage dispute, and the consumer saying, well, I didn't agree to anything. I had no choice but to agree. So
right,
it is nice to make that point, whether you knew it or not, you did.
Yeah.
And this may tie in somewhat to the next section, but I think it also applies to preparing your client for arbitration in this day and age, is talk to your client about what they would be more comfortable with, an in-person hearing or a Zoom hearing. The majority of the hearings that I conduct now are by Zoom, but that may not be the right procedure for your client. Give them what are the pros and the cons of in-person versus Zoom. They may feel strongly that they want to be in the room with the arbitrator and with the opposing party. Or conversely, they may be in Colorado and would prefer to not travel to Alabama for an arbitration. Tell them that there is the option of conducting the hearing virtually on Zoom.
Yeah, this may be a good segue to something that's not even on the outline, but we've talked repeatedly and we'll continue to talk about preparation because I think that's probably often overlooked. But if it's going to be by Zoom, and Brooke, I'm like you, a lot of mine have been that way in the last few years, but you need to be prepared and the client needs to be prepared just technically to accomplish that. And I know, and I'm sure you've had the same experience, the best laid plans and preparation can get kinks in them, but you help yourself if you've at least sat with your client and made sure that they actually can use Zoom, not that they just say they can. And, when you ask the parties, are you familiar with Zoom? Everybody always nods. And then you try to get on and do an arbitration and you spend so much time fighting and fussing with the technology, and it's not that complicated and it just takes a little preparation. So,
Or the clients on their cell phone in their car.
oh, absolutely. Or in a gym. I had some guy, we went back to the waiting room and I'm like, where are we? And what about, and that's a segue to our next topic, privacy and confidentiality. John, I don't know about FINRA, but if the arbitration is supposed to be private and confidential, how do you ensure that? And does FINRA, is that provided for by the rules?
Yeah, I mean, it's hard. You have to have that conversation with all the parties, and they have to have it with their clients if you're not. Because especially if it's Zoom, I mean, obviously, if it's in person, it's not as much of an issue. I mean, it's still an issue, but it's not, something where people could be in a car with 5 other people there.
Right.
So you have to let the parties know and the attorneys know that this is a confidential process. And that, frankly, and this is getting a little off too, that's one of the issues a lot of people have with arbitration is that it's confidential and private. So it's taking away from that public, openness as far as, a litigated case is public record. So, and taking away from precedent. So, but it is a private process and you can't be publishing it to everyone.
Of course, that's one of the benefits of arbitration, depending on the perspective that you come to the case with, is the privacy and the confidentiality. Right. Regardless of what the outcome of the case is, you can rest assured that it's not going to be broadcast. It's not going to find its way onto a billboard. And so that is an important consideration for a lot of parties.
Absolutely.
Yeah. And I think people forget that too. It goes back to reading the rules as well. John, how about our next big topic, what to expect in arbitration?
Yeah, I think, this takes a lot into consideration. And as we started off here, and I think if everybody wants to look behind your outline in the bios is the AAA rules. And you can also go to the website. But that is probably one of the principal things that you need to consider before you get started is the rules of the organization. If you're using an organization, what are the considerations when you consider those rules? Cooper?
Yeah, so I think the AAA has at least 3, maybe 4 sets of rules. There's a commercial dispute resolution, construction, employment, consumer. And then they have expedited tracks for some of those. And they're different. I mean, they cover the same topics, but they have different provisions. So when someone just says, oh, well, AAA rules apply, well, which ones? And how do they differ? And just because, one set applies, do we really want those rules? Or as we said from the beginning, do we want to agree to something else? But, reading the rules and then getting some agreement on what they are or how they're going to be applied is just critical to do at the beginning of the process, because they will answer a lot of the issues and questions that come up. Is that been your experience, Brooke?
Yeah, absolutely. And it's frequently the case that an advocate gets into arbitration and we're at the preliminary hearing stage, and they're surprised to learn that the rules don't provide for whatever they want, such as extensive discovery, or the rules require that the case be heard and decided within 30 days, not 6 months. So be familiar with your rules before that first preliminary hearing and scheduling conference with your arbitrator, because oftentimes you will be surprised to learn what those rules do and don't provide for.
FINRA has separate rules also. They have, some of the FINRA cases are industry cases, say a broker versus their brokerage house, whereas a lot of them are public cases where it's a consumer versus their broker, and there are different rules for the different types of cases you have. You definitely have to be familiar with them, and the arbitrator has to be familiar with them. Looking at when you get started in the process, I know when I do FINRA cases, we have that preliminary hearing, and I'm sure AAA, and I've been involved in AAA, they do the same thing. What are some of the considerations we need to look at with the preliminary hearing from the advocate's point of view?
Well, I'll start off. And AAA does have a preliminary hearing that is required of all cases. Once you've selected an arbitrator, that's the first step in or I guess the next step in the process to have the preliminary hearing. And you can see on the outline that the very first bullet point is prepare. Most often when I am serving as an arbitrator and we have this preliminary hearing, the parties get there and they have not spoken to one another yet, or the advocates, the attorneys have not spoken to one another. It's helpful if the attorneys get together before this preliminary hearing stage and try to agree upon a schedule. If we can, we would like to set the final hearing in August. Instead of going through all of these things at the preliminary hearing stage, I think it's really important that the advocates discuss these issues before we get there. Because otherwise, we're going to spend an awful lot of time running through the various steps for scheduling order, the hearing date, the witness and exhibit lists, and discovery and things of that nature. So always be prepared before that preliminary hearing begins.
Yeah, I think those are certainly great points. And I know I'm always excited when I get on a preliminary hearing and the lawyers say, hey, we've talked, we're going to send you a preliminary, or we plan to talk even and send you a proposed scheduling order, because they're going to have to deal with each other at some point. Let's go on and break the ice. And you don't need, an arbitrator imposing a schedule on you when you all know what you need. A number of the cases I have are just one of a multitude of arbitrations between different consumers and perhaps one company. And so it's the same lawyers in every case, and they usually have a form that they use, and that's great. But if it's a one-off arbitration, doing that sort of thing ahead of time will set a good impression with the arbitrator, which is important for both parties, that they are prepared. And I think it'll get you off on the right foot.
And it does
And will save time and money, especially if you're paying by the hour.
That's what I was going to say.
Yeah. And that's important for your clients, to streamline the process as much as you can, rather than having us as an arbitrator on the phone for an hour. If you've talked before you get there, maybe the preliminary hearing only lasts 20 minutes.
I think sometimes also people look at arbitration as a less formal process. Most of the attorneys that are coming to arbitration, they've been in litigation, they've been in federal court or state court, they know what's required, they know what has to be done. And the same things have to be done in arbitration. You can't go forward without some type of plan, without a schedule. So get together with the other side or multiple parties and work it out, and it'll save you time and money. And who wants to sit on one of these Zoom calls for 2 hours when you can do it in 30 minutes?
Right.
Except for when we're giving a webinar.
Yeah. And you're getting CLE credit, right?
So talk about some of the documents and that process as far as not necessarily the preliminary hearing as much, maybe just the whole process dealing with the documents that are involved.
Yeah, I think that, the rules are going to require some sort of disclosure at some point, at a minimum. And having some familiarity with what is going to be a relevant document, and therefore what exists, what doesn't exist. Are we talking about millions of documents or 12? I mean, if you know some of that before you get to the preliminary hearing, it could be that we can address how they're going to be produced or when they're going to be produced or whatever. That would be a separate, hearing or conference later, sort of merging into the discovery issue. Let's go on and talk about it, and if the parties have already discussed it, we really want their, whatever document, and they don't want to give it to us. Okay, well, we know that's going to be an issue. Encourage you to work it out. But if you can't, then we'll set a separate hearing for it, whatever. Or, maybe it's as simple as, let's decide it now. Are we going to get that or not? I don't know. If you've got some idea, not just of what the case is about, but what it's going to involve to get ready, it's just helpful. And to know whether the parties may have even already exchanged it. Maybe it's already in their possession. Brooke?
This is the issue that surprises both the attorneys and the parties more than any other, is discovery, what is and is not allowed. And the AAA stresses over and over to us as arbitrators to not allow this to be like going to federal court. The rules, while some of the rules may provide for limited discovery or request for production or limited number of depositions, other of the rules don't allow any of that. It's just a document exchange. And parties that come to me as an arbitrator with a proposed schedule or during the preliminary hearing tell me that they wish to have 8 depositions and 40 interrogatories and 25 requests for admissions, are surprised when I say no. One of the benefits of arbitration is that it is intended to be less costly, and discovery is the single greatest cost of litigation. And so you need to think about, before you get to that preliminary hearing, what is it that you just have to have, and what is it that you can live without? Because odds are the arbitrator is not going to give you everything you want. The rules may not provide for any of it. But if I have a party and the parties both agree that they'll take limited depositions, then I can agree to that. If the parties tell me that they want 8 or 10 depositions, I generally don't allow that, even if the parties want it, because that defeats one of the primary benefits of being in arbitration, and that is reduced cost.
And the only thing I think I would add, Brooke, is with respect to all these documents, and we can get into e-discovery if we want, but get with the other side, know what documents are important, and agree on what documents are going to be produced at the hearing. You can already have them pre-marked. You could the evidentiary rules in arbitration are a lot more liberal. The arbitrator doesn't have to go by all the particular rules. And you got to remember that this is a forum that's designed to be efficient and speedy. And there's usually not a smoking gun anyway. So playing hide the ball really doesn't get anybody anywhere, except cost more time and effort and money.
Yeah, you took the words right out of my mouth, John. I think, some people see the lack of formal and extensive discovery as an opportunity to hide the ball. And that has come back to bite many, because there is going to be some requirement for disclosure of relevant documents. And if a witness is on the stand and references some manual that you pretended didn't exist, that's not going to go very well. And it should go without saying, but I think lawyers have a difficult time sometimes shifting gears. We're not in litigation, we're in arbitration, our clients agreed to it. And how do we advocate in this forum and it's different. And some are really good at it, and some who are great trial lawyers just don't get it in arbitration.
Yeah, I think I found as an advocate in arbitration before I became an arbitrator that you do over time get used to the idea that the only discovery you're going to have is the documents that you receive from in the document exchange, and you learn that you can in fact prepare a case and arbitrate it without the extensive discovery that you might otherwise have had in federal court. You do find that you can get by with a lot less than what you're used to in court.
That's true.
You know, I've been practicing for 30 years, and y'all been practicing, I guess, about the same amount of time. I've not, and maybe it's just I'm not that best trial lawyer in the world, but I didn't have many Perry Mason moments. I don't know about y'all.
I haven't had near enough, that's for sure.
So we've talked about some of the preliminary hearing, the discovery, and we're getting towards the end. Let me remind everybody, if you have a question, please put it in the chat box. We're glad to address them. We don't have to go through our whole process. So we've got down here about the arbitrators, the decision maker, and probably not as familiar with your case. What are your thoughts on preparing the arbitrator, Brooke?
Well, for those of you who have filed demands for arbitration, you frequently, all you will file with the AAA to initiate a case is a 1-page or 2-page document that really does not give much detail. So I usually like to request that the parties provide a detailed statement of claim and that the respondent provide a detailed answer to the claim to give me a little more background. I don't want to come into a final hearing having really no idea what the case is about, because there's so little motion practice. Without that detailed statement of claim, I may not have any real familiarity with the case or the background of the case. So it's important to me as an arbitrator to have some idea what the case is about before I get to the final hearing. And sometimes parties request that they file pre-hearing briefs, and I find those helpful too.
Yeah, I think a lot of cases that we end up arbitrating have been, pushed there, perhaps from a court filing, and the complaint gets squeezed into the arbitration complaint form, see attached. And we all know that the rules in court really require us to plead pretty broadly, unless, or we're going to waive a claim. But I think we got to throw all that out the window when it comes to arbitration. Streamlining the theme, what is the case really about, is an art, and it's more important than ever in arbitration. And the fact that you don't have discovery in the form of depositions, for example, doesn't mean you should take a deposition during the hearing, of the witness. I mean, it needs to be a streamlined, prepared presentation. And again, some people are great at that. And some people have trouble shifting gears to do that. But Brooke, I think, having something ahead of time, certainly in writing, that just sort of clearly, succinctly, briefly sets forth, this is what we're going to be dealing with. These are the principal issues. I think that's a great tool that when used.
Brooke, you touched on it, but and it probably goes without saying, but talk about motion practice in arbitration, summary judgments, motions dismissed, and so forth.
Yeah, the AAA, they also push, well, I wouldn't say push, but encourage arbitrators to not allow the cases to look like they might in federal court, with lots of motions to dismiss, motions for summary judgment, or dispositive motions. But with that said, that doesn't mean that certain cases don't lend themselves to that. If there is an issue that you can get rid of with the dispositive motion, so that it is not going to be a part of the final hearing, raise that with the arbitrator in the preliminary hearing, request permission to file dispositive motions, and I usually allow the parties that opportunity. I put a limit on the pages and the number of exhibits, but it is not going to be a free-for-all with motions to dismiss, motions to compel, motions for summary judgment. That's just not part of the arbitration process. But under limited circumstances, you will have an opportunity to file a dispositive motion in most cases, or at least in most that I arbitrate. Consumer cases don't typically allow that.
Do you want to add anything to that, Cooper?
No, I agree. I think he's spot on. I did see a question from Susan I could answer if you want,
Yeah.
or we can answer. Susan says, if the AAA says the commercial rules apply and the fee is $7,000, can the party still agree to apply the consumer rules for the lower fees? And I think, again, I'm not speaking for the AAA, but there are certain jurisdictional thresholds or limits on what consumer rules will apply to. And if you've agreed that the AAA is going to manage your process, then they're going to manage it in accordance with your agreement. If their jurisdictional rules would allow the consumer rules to apply and the parties specified commercial, I think they can then agree that they're going to use the consumer rules, or they may not have AAA manage it. And I think they'll be a little more flexible with you if they realize, they're not going to be doing anything. I had a case, for example, a year or two ago where the parties called me about a private arbitration. And I looked at the rules. It was AAA. It didn't specify. And I said, well, hey, you can do this with the consumer rules through AAA, and it's really not that expensive. And I'm capped at $2,500 a day for a hearing, as opposed to an hourly rate. So it's cheaper if you go to AAA and use the consumer rules. And so I don't know exactly what they would do in that situation, but it doesn't hurt to ask. And if the parties agree, then you're going to be much better off trying to accomplish that. Brooke, have you had experience with that with AAA?
I have not where a party, yes, where the parties do decide that they want the home construction rules to apply rather than the construction industry rules. But whether or not that translates to a different fee structure from the AAA, I'm not sure.
I don't know.
That would be something for the AAA to address.
Mary Ruth Smitherman's asked a question. If the parties decide not to go through AAA or JAMS to arbitrate, what is the best practice for the parties to pick an arbitrator? We touched on this a little bit earlier, but I would say that the first thing I would say is talk to the other side and decide, how y'all want to go about picking an arbitrator if you already have some names to suggest. However, the Alabama Center for Dispute Resolution has a list of registered arbitrators. So you can always go there to get a list of registered arbitrators in the state. Any other thought?
By subject area as well.
Right.
You have a consumer case or an employment case, there are lawyers on there under the employment pull down that have experience arbitrating those cases. That's a very good place to start.
Yeah, I agree.
So we're down to about a few minutes left. Do y'all want to try to hit section 5?
Yeah.
Brooke?
Okay, section 5, these are the final considerations. Cooper, what about grounds for appeal, and what do you find? Are attorneys surprised by the rules regarding appeals?
Well, yes, but parties are probably more surprised. So they may have talked to their clients about, hey, here's what arbitration is, here's how it works. That's for, and you get to the end and, bang, it's over. And as an arbitrator, I don't often see or hear this, but I hear about it from friends, lawyers who are doing it. It's like, gee, my client had a difficult time understanding there's no appeal. And you can search high and low for cases where arbitration decisions have been overturned, and they're fewer and fewer and fewer. And I will say that the third party administrators of arbitration are very keen on how things get overturned, and they do their best to prevent it before it happens. So part of our training with AAA is how to avoid those things, which really is disclosures and being fair and impartial, et cetera, and doing what the parties ask so far as an agreement is concerned. But
it concerns the parties that there is no good means by which you can appeal an arbitration award. But I know as arbitrators, we want to get it right. We
Sure.
hope that there's not a party at the end of the day who feels like, gosh, I wish I could appeal that award. I mean, we arbitrators all want to get it right.
Yeah,
Yeah.
I saw an arbitration agreement recently. I'd like your thoughts on this. It had in there that the parties had a right to appeal to the appellate courts. What's your thought on that?
I've not seen that nor dealt with it, but gosh, and I don't even know.
Procedurally, how would it work?
Yeah. So is it treated like a non-jury trial with all the ora tennis rules, that sort of thing applicable? And does the appellate court actually have jurisdiction just because the parties agree? Wow, that's,
Very,
I don't know.
99% of the time, there's not going to be a transcript of the final hearing.
right.
Right.
And the parties, if they want a court reporter in there, they can certainly do so, but it's rare that there is going to be a transcript of that final hearing, making an appeal all the more difficult.
Right.
Yeah.
So, we have some other comments here about the arbitrator, and obviously the arbitrator's like your judge, so you need to be respectful. What about some thoughts on post-judgment communication? I've kind of usurped your role here, Brooke. Sorry.
No, that's fine. I've had one instance where one of the attorneys attempted to contact me after the award, and I just politely declined talking to them because the AAA tells the parties and tells the attorneys that once the case is over, that there is to be no communication with the arbitrator. So that is a rule that they stress: just do not engage after the award.
Yeah. And there's a provision, or maybe in some of the rules, there's provisions for, there's a certain amount of time after the award is entered. If you think there's some mistake,
Sure.
you can raise it through the rules, and that's the way to do it. And I mean, people make mistakes, gosh, well, I didn't realize that fees couldn't be awarded, or there's a typo and the interest calculation is wrong, or whatever the case may be. There's a mechanism for that, but separate and apart from that, it's just not good practice or form. And in fact, you have to appreciate from the arbitrator's position, certainly with AAA, we can't, it's
Right.
gets us into trouble.
Well, I think we've hit the 1 o'clock hour. I appreciate it, John and Cooper. And John, if anybody wants to get in touch with you after this, how do they get in touch with you?
Sure, and I'll put it in the chat box, but I'm John at birminghammediators.com. My name is Jon, not JOHN. And my number is 205-254-6060. Feel free to contact me either way. I'm also on various social media sites. You can contact me there too.
Cooper, how about you?
Yeah, mine's easy. CooperShattuck.com, and my numbers and email and everything. You can get me that way, or Cooper at CooperShattuck.com. So as long as you get Shattuck close to the spelling, you can Google it and find it.
Okay, and then my contact information is Brooke, and that's with an E, .Lawson at chlaw.com. And if anybody has any questions about any of the topics that we covered today and you just didn't have time to ask them, feel free to contact us. We'd be happy to.
And we thank everybody for joining, and thank y'all. I enjoyed it.
Thank you,
Eileen?
Thank you, panelists. You've done a great job and given us a lot to think about. Thank you, everyone, for joining us today. I will also point out that all three of our panelists are registered with the Alabama Center for Dispute Resolution. So you can always go to www.alabamaadr.org under the heading Mediators, Arbitrators, and you can search for them there. So thank you, panelists, for a wonderful presentation. Thank you, everyone, for joining us.